as regarding academic adjudication as an exception to the principle of natural justice, we would like to discuss the leading case Jawaharlal Nehru University versus B.S. Narwhal. In 1980, the Supreme Court observed how it is an exception to natural justice. So, the Supreme Court has held that the very nature of the academic adjudication appears to negate any right of hearing. In this case, a student of the university was removed from the role of the university on the ground of unsatisfactory academic performance without giving him the opportunity of being heard. It was held valid. The Supreme Court has made it clear that if the competent academic authority assesses the work of a student over a period of time and thereafter declare his work unsatisfactory, the rule of natural justice may be excluded. It is to be noted that this exclusion does not apply in case of any disciplinary matters dealing with students as taken by the university. So, this kind of academic adjudication regarding unsatisfactory performance of a student and the very assessment regarding his cancellation of studentship by the university is held is not violative of the principle of natural justice. And now we'll go to the ninth exception, that is when no right is infringed and how it is falling under an exception to natural justice. And in that context, we will discuss the important leading case J.R. Vora versus Indian Exports House Limited in 1985, and the judgment was delivered by the Supreme Court. If the right of a person is not judicially affected, the application of the rules of natural justice is not attracted. As under the Delhi Rent Control Act, limited tenancy can be created and it can be terminated on the expiry of the term, and if the terms of limited tenancy is expired and warrant of possession is issued to the tenant without any notice of hearing to him, the warrant of possession cannot be held to be invalid on the ground that no hearing has been given to the tenant before the issue of the said warrant. The reason is that after the expiry of the period of limited tenancy, a person has no right to retain the possession, and therefore, by the issue of the said warrant, no right has been violated, and as a result, the application of the rules of natural justice is not attracted, as it was held by the Supreme Court regarding the petitioner J.R. Vora versus Indian Exports House Limited as an exception as there was no infringement of the right of the plaintiff, as already it was mentioned under the very Delhi Rent Control Act regarding limited tenancy. So there is no violation of the principle of natural justice. And now we'll go to the 10th one, that how the very interim preventive action is also falling under an exception to natural justice, and in that context we will discuss the leading case Abhay Kumar versus K. Srinivas, 1981, the Delhi High Court's observance regarding application of interim preventive action. So the rule of natural justice is not attracted in cases of interim preventive orders. For example, the order of suspension of an employee pending an inquiry against him is not final, but interim order and the application of the rules of natural justice is not attracted in the case of such order. So, as it was decided in Abhay Kumar versus K. Srinivas, and in 1981, the Delhi High Court order was passed by the college authority debarring the student from entering the premises of the college and attending the classes till the pendency of a criminal case against him for stabbing a student. So the Delhi High Court held that the order was interim and not final. So it was preventive in nature. It was passed with the very object to maintain peace in the campus. So the rule of natural justice were not applicable in the case of such order. And the last exception that we will discuss, and that is regarding in case of fraud, how the very principle of natural justice may not be applied. And regarding that, we will discuss the very important leading case UP Junior Doctors Action Committee versus Dr. B. Sital Nandwani in 1991, and the judgment was delivered by the Supreme Court. So, regarding the very question of fraud as an exception to natural justice, the very admission was obtained by fraud was cancelled without providing opportunity of hearing to the affected candidates was held valid by the Supreme Court, as the rules of natural justice were not attracted. So, in this leading case, UP Junior Doctors Action Committee versus Dr. B. Sital Nandwani, some students secured admission in the postgraduate medical course in the medical colleges by producing fake order of the court. Their admission was cancelled without giving opportunity of being heard. The court held that the circumstances in which such benefit has been taken by the candidates concerned do not justify the attraction of the application of the rule of natural justice, and Therefore, the cancellation of admission could not be challenged on the ground that no opportunity of hearing was given to the affected candidates before passing the order of cancellation of admission. So, in this very case, Supreme Court has made it clear that opportunity of hearing is not necessary before passing the order cancelling the admission of the candidates when such admission has been secured by fraud. So, these are the 11 exceptions that we found regarding the very application of the principles of natural justice, and in particular the very principle of the alterum partem, when it would not be attracted in case of very alleged that the very principle of natural justice is not applied. So, these are the 11 situations or circumstances as we discussed with certain leading cases. Under those situations or circumstances, the very rules of natural justice and basically the fundamental principle of adi alterum partem could not be applicable, as expressly these were held by the decisions of the Supreme Court and of certain high courts. So, in our upcoming video, we will discuss shortly those failures to give reasons, and regarding that also we will discuss the important leading case Travancore Ranch versus Union of India 1971. The decision was delivered by Supreme Court, and the next one, that is the Ajanta Industries versus Central Board of Direct Taxes in 1976 case, and the judgment was also delivered by the Supreme Court.